Hey there, everybody. Jonathan here. I've got Stephanie Joy with me. Stephanie, how are you doing?
I'm great. How you doing?
I'm doing great. And I know last time we had you on, there was some issues with some echo, so I'm sure our audience will tell us if we're having echo problems again. I don't hear anything, so I'm thinking we do not, but who knows? We'll see how it goes. So as we always do, we're going to be taking questions people have. I already see a bunch of questions that have come in. I'll post them on the screen, and Stephanie and I will kind of just jump in and try to answer these questions. If you have questions about, different types of cases, impairments, continuing reviews, anything on your mind, this is the place to ask them, and we will do our best to answer them. So Christina is one of my regulars. She says hello from California. Hello, Christina. And she's always very nice to say, please do not forget to like, share, comment, and subscribe. Absolutely. So she is
Hi, Christina.
my informal social media manager, I guess. Okay, so June says, I'm on SSDI, but took a job at $800 a month ago. Terrified they're going to take it away. Advice, age 58. Steph, what do you think?
I think it's probably not an issue at all. She's in the trial work period. Obviously, keep up with your medical evidence. And so they're not going to find you medically not disabled. Because they can do not a CDR, well, they could do a CDR, but she's got that, they can't do it because of her work, right? They can't look at her work, it's under TWP.
Yep.
So I think you're probably good, June, unless like you have a back impairment and you're baling hay at a farm, like doing something really contrary to that impairment.
Yeah, I mean, I think that, the question I get is, if you're working at all, is that going to trigger a CDR? And I would say, realize Social Security has the trial work period program, which is designed to encourage people to go back to work. So if you're below that, you're trying to work, I don't think that would trigger it at all. Now, the question is, if you use up your trial work period months, and again, I think it's $1,110 in 2024. I think it's 1160 maybe in 25. I'll look that up in a second. But whatever it is in a 25, let me just pull this up real quick. So the question is, let's say you use up your trial work period months and you're still below SGA. Would that be something that might trigger a review? Because Social Security is seeing earnings coming in, through the tax records and so forth. I don't know. I get the sense that these CDRs, at least at this point, are a function either of random, it's either random or they code you, based on the type of impairment you've got. I have a client, a longtime client, who claims he's figured out the code. I've still not need to get him to explain it to me, that when he got his short form, and the short form is basically where they ask you, are you working, and if you had any medical improvements, stuff like that, that they're on the address label, there's a code that basically will tell you that they believe you are likely to be have medical improvement or not. So I think that in my mind, it's, the nature of your impairment and your age are going to be the factors that are going to do it. There's also a random factor to it as well. Now, all this is, that could all change. We got a new administration coming in. There's going to be a new commissioner. It could be very different. But right now, I think if you're making $800 a month, I don't see that as a problem. If you were making over the trial work period and you're below SGA, the question might be, are you able to do more? And therefore, that might trigger something. But I think at the end of the day, the amount of money you get from Social Security disability is not that much. If you can supplement it with $700-800 a month, I would do that, and I wouldn't worry about it. I don't think that figure is not, would to me, would not make me nervous. Is my take on it.
Yeah, I think under the trial work period is very good. I think they're probably, if June reported it to them, which she should, they might give her an 821 or an 820. If she's employed, I guess it would be an 821.
Okay, the form.
And then they're going to find out that's how they know you're making under TWP, or under SGA.
Yeah.
And then you kind of describe, I think.
Yeah, what you're doing. I mean, look, at the end of the day, they want people to try to work, and they want to get people off the disability roll, so they encourage people. And if you're below a trial work period, I don't think that if let's put it this way, if word got out that working under trial work period was going to trigger CDRs, and there was evidence of that, and I'm sure there'd be people who would keep statistical analysis of that, then nobody would ever work. So
Exactly.
I don't think that that's going to happen. All right, so trial work period in 25 is $1,160, and SGA is going to be 1620. So, certainly if you exceed SGA kind of on a regular basis, that could trigger it. But I think otherwise, I would not worry about it, June. I know we spent a lot of time on this question, but
I love that she's doing it.
yeah, right, absolutely.
It's one of my.
Look, I mean, I'm sure you tell your clients as well, you're going to be much happier working. You're going to be much more fulfilled working. You have interaction with other people. You feel like you're contributing. So, disability obviously in some cases becomes a permanent thing, but you don't necessarily need to look at it like that. It should be something that, you're trying to get off of. You're trying to get better.
Yeah, and it doesn't mean you're not productive in any shape, way, or form. You just can't do it full time. You're
Yep.
unable to do it full time, and you're unable to do it SGA.
Exactly. Okay, so Sandy tells us, hello, Sandy. Carrot says, blessings to a super lawyer. You need my assistance. Okay, well, you see you can get a case evaluation there. All right, Sparkle TC. I think Sparkle's been on before. Looking forward to the conversation. Okay, well, very good. Lachina, you always go to person with questions, guidance, caring education. Okay, thank you very much. I really appreciate that. Very kind words. And I think the same goes for Stephanie. I think both of us feel, and there's a lot of lawyers in this area who want to share what we know because the system is such a black box. It's so difficult to kind of navigate. And, you want to let people know about it because those who really need it, it makes a big difference in their life. And I know, I'm sure you feel the same way. When you get somebody on disability who really needs it, who can't otherwise function, it's a good feeling. It really is very satisfying.
Absolutely.
All right. Hi from Texas, a big one. Rodney is one of my office. Actually, I didn't handle this case. Another attorney in my office handled it. But Rodney and I have communicated a good bit, and I got him the audio. We got it so he could listen to it. Rodney, I have to ask you, were you able to listen to the audio? I converted it to an MP3. So I think you should, I know you came by and picked up the disc. An Amazing Grace Ranch. I have a question about SSDI. When it says total disability is awarded for 5 to 7 years, what happens in the 7th year? They send you a letter to make you reapply, or is that the end? No, there's no reapplication. Basically, what they're doing, I mean, generally speaking, if Social Security puts you on a 7-year review, they're in essence saying you're permanently disabled. If they put you on a 1-year or a 3-year review, they're saying they think there's likely medical improvement going to happen. So at that end of that 7 years, they may send you a form, either the long form or the short form, to fill out. Most of the time, based on how you fill it out, there'll be nothing that happens. But in some situations, if you have ongoing work, if there's been medical improvement, things like that, they could move to terminate. Of course, you can appeal that, which raises a whole separate issue because, if you appeal it and you choose to have your benefits continue, which again, one of these crazy things in the law, you have 10 days to ask the benefits continue. But if you do that, of course, there's no past due benefits, so you can't hire a lawyer on a contingency. And if you choose not to have benefits continue, you starve, while you wait. So it's kind of a real difficult choice. But the answer is no, you don't have to reapply. You basically wait. You know what? This is a case of no news is good news. Wait for them to contact you, is what I would say. Agree?
Yeah, absolutely. I would also say, this just came up the other day too. Total disability. I always try to say it's not total disability. You're either disabled and you get your full benefit, or you're not disabled according to their definition and you get nothing. It's not like a total versus a non-total and you get more or you get less. You get what you paid in, and then, and you don't have to be totally disabled, because as we're just talking about, you can work part-time if you do it within the rules.
Right. Well, look, the concept, the definition of the word disability, I mean, if you think about it, and I was having this conversation with a client the other day, the VA has one definition of disability. Social Security has a definition. Insurance companies have a definition. I'm sure that the federal government in some of their programs have so the word disability is not a set term. I mean, it can be defined any number of ways. Social Security says it's defined in terms of your capacity to work, and it has to be a condition that prevents you from engaging in substantial gainful activity, which, financially is in 2024, $1,550 a month gross, okay? And it has to be something that has lasted or expected to last a year. So, there's a duration requirement and there's a number requirement. And of course, it could also be if your activity. So there's any number of ways that they define disability. There is no partial disability in Social Security. People ask me that. Is it? I can't do my past work. Can I get on disability? No, there's no partial disability. And there's also a question I get a lot. I'm not sure if you do. I'm on SSI. I want to upgrade to get SSDI. Doesn't work that way. SSDI is based on your earnings, what you paid into the system. SSI is based on you don't have enough earnings for SSDI, really. But total disability, yeah, I think that's a difficult phrase because disability is, do you meet the definition? And you may have some capacity. Look, the grid rules say you are disabled even if you retain the capacity, in some cases, for light work. So you could be able to do work at the light exertional level, which is standing 6 hours, lifting 20 pounds occasionally, and you're still disabled for Social Security purposes, but obviously there are a lot of jobs you could do. Again, you can't do them and earn more than the SGA amount, but you could theoretically have the capacity to do a sit-down job and earn, $1,500 a month and still be on disability. So it is it's a loaded term, but you need to understand what it means because that can make a real difference in your life. And I would submit that if you can earn $1,500 a month in addition to your disability, that can make a difference. I mean, disability doesn't pay that much. Let's say you're getting $2,000 a month and you can earn another $1,500. Well, you may almost doubling your income. So,
Yep.
I think you got to really be aware of the definition and how it all works. Okay, Kay Wolf says that it's snowing in Maryland. I'm in Atlanta, and it was 45 degrees here, so that's like ridiculously cold for here. What is it in Stroudsburg, Pennsylvania?
I don't even know what it is right now,
Yeah.
but we have, our roads are salted.
Yep.
We're expecting snow. Although I was out earlier after my regular day, and someone told me that now we're only expecting flurries. But it was a guy at the gas station, so I'm not sure.
not a certified meteorologist. Yeah.
No.
Yeah.
And it's funny, speaking of gas stations, for all the Pennsylvania people, I come from Jersey where you don't pump your own gas.
Right, that's right.
And in Pennsylvania, where I am now, you pump your own gas. But there is this little, very antiquated gas station. I'm in East Stroudsburg, and they pump gas for you. So I always go out of my way to go there because someone's got a job.
Yep.
So I'm helping that. And I don't like pumping.
Yep.
And it's a little bit more money, but.
I mean, and this is unrelated to Social Security, but I've always wondered, what is the deal with New Jersey? Why do they refuse to let people pump their own gas?
I'm guessing it's a liability thing.
But every other state, I mean, I'm thinking there's some sort of a somebody has some clout someplace that passed this law.
I'm sure it comes down to everything does in Jersey.
Yeah, I guess. It's just crazy. I mean, I haven't gone to a full service gas station in 25 years. So, I mean, everything in Atlanta is self-service. I mean, you have to like go in and I mean, I don't know that most places even have somebody who could pump gas for you. But anyway.
When I moved here, and I was not a child, I was in my 30s, I kind of had to learn.
Learn how to do it. Yeah. Well, when I was growing up, that's what you did. You go to the gas station and 3 guys would run out and they'd check your oil and they'd check your tires and do,
Yeah.
So, there's that scene in Back to the Future, the first one, where, Marty McFly, Michael J. Fox's character is going back in the future. And of course, where he's in, present day, or at that time, present day, he's not pumping his own gas. And he goes back and he's just amazed that these guys, 5 guys come out in uniforms, neatly pressed uniforms and do all the service on his car. So Okay, well, let's get back
Great
to
movie.
business. Leanne says, the ALJ assigned for my hearing has a 31% approval rate for 24. How do you approach low approving ALJs? Thank you in advance. I have one coming up with a 17%, and I got another one with a 15% judge. So I'm not thrilled about either one of those.
I'm thinking, is 31 close to the
average is 48, I
state?
believe. The average is
Oh, is
48.
it that high?
Yeah, nationally it's 48. The last waterfall chart I checked was 48, but 31 is definitely low. There are, and I've had cases with 31% judges. I've won them; they're good cases. But I think that in my mind, the biggest difference is, if you're over 55, even if you have a 30% judge, you still have a decent chance at it. I think where those judges are different than the 55 and 70% judges are, they're not going to approve younger people. They're not going to approve cases where things are subjective. They're not going to approve cases unless there is clear evidence of an impairment. They're not going to listen to anything you say. It's all going to be in the medical record. So I think that what I do with those judges is, number one, I do a pre-hearing brief in almost every case anyway, but I do a pre-hearing
everyone.
brief, that spells out my argument. Obviously, if the person is over 55 and I can make a grid rule argument, I do that. But otherwise, it's kind of if you're 45 and you've got mild to moderate problems in your back, and let's say a bulging disc, and you've got mild to moderate depression, it's not going to go well, my guess. So that's the issue. What's your take?
I think that's probably a good theory on which ones, because I agree. I don't think it's going to be so much the ones that actually meet these special rules with the grids and all that.
Yeah.
Although I will say, I don't look up their rate.
No, I do.
Nope. Because I used to do that back in the day. I haven't done it in a really long time, but it kind of can be. It might not be now, because now but back then it would be a little disheartening when you see a low number. And if my client asks me about the number, I don't even want to know it, because I'm going balls to the wall regardless.
Yeah.
So I treat them all the same. I do the top brief I can do. And I don't let anything sway me from that. Like I don't want a highly rated guy, to make me. I can't imagine this could happen.
You're already complacent, right?
I don't want to. Yeah.
Yeah.
So
Well, I mean, I do look because I want to know, and I also will check the NOSCR listserv, and so if I've never been in front of that judge before, I'll ask what do I need to know? Is he is he or she unpleasant? Do they like briefs? How do they conduct their hearings? I like to know that. I will tell my client that, look, even the low paid judges, they approve some cases. Now, a 15, 17% judge, those are really getting low. And I've often wondered whether you could argue an appeal that they're so far out of the average that it is inherently unreasonable. I've never made that argument, but I think that a 15% approval rate is so far below so many standard deviations, if I can remember my
right.
My statistics class from college, that there's an inherent problem there. Of course, I assume I'm going to have to appeal that case, so I may prepare my questions for the vocational witness a little bit differently. But you just have to go in and present the best case you can, and you can't assume anything. So again, even the low-paid judges will approve cases. At 30, this judge has approved 31% of claims, and you also, it very well could be, look at how many claims that he or she has adjudicated. What happens if he's adjudicated, 25 claims? Well, 31%, that doesn't really tell me very much. If he's adjudicated 300 claims, that's a better statistical number. So there's a lot of factors that come into play. But I get what Stephanie's saying. Is you don't want to go in with a feeling like, oh, I know I'm going to lose or I know I'm going to win. You just want to present your strongest possible case, is what I would say. And
be ready. He's preparing you for appeal too.
Yep. And
Leanne
also,
like, as you're going through the case and the hearing, you're always kind of multitasking with, you're doing this now, but you need to make sure this is preparing for that plan B.
Yep.
To get that judge that.
Yeah. And Leanne says, how do they assign? It's random. They have like I don't know how, there's probably a computer program where they press a button and you just happen to get that judge. Now, I have wondered if certain judges like to do cases on Fridays or Mondays. If I could find that, it would be kind of interesting to know, because we can now tell Social Security what days we want to have hearings. So, if I
Oh,
happen to,
man.
if I happen to, like, there, I'm in Georgia, there's a couple of judges that I don't particularly want to get in front of. And so if I know this particular judge, is always likes Friday cases, I'm not going to ask for Friday hearings in the fourth, circuits or the fourth district or whatever. So
That would be
I-
good info to
it
have.
would be good info. Maybe a Freedom of Information Act would be in order. That would be kind of interesting to know. Of course, they can always change it.
Yeah.
Anyway, but it's random at this point. L. Brown says, good evening. Good evening. Melinda Damon, hello, everyone. Hello, Melinda. Hope you're doing well. Stephanie, one of your fans, is here, which is always a good thing. People, even when you're not on, people will say, "Hey, how's Stephanie doing?"
Uh,
Well,
well, they always talk about you, Jonathan.
Yeah, Kakara is obviously into the emoji scene here, so a lot of emojis there. Okay, Eric says, I've been on Medicaid for a year and a half, been using it a lot. Does it have to be repaid? Don't know why it would need to be repaid. I mean, no, I don't think so. I think if you're on Medicaid and you qualified for it, either as an adult medically needy person or because you're an SSI, you get it. And as long as you're an SSI, you're good. I mean, if they should terminate your SSI, then that could be an issue. I'm not sure when Medicaid runs out. I don't think it's right away. I don't know. I shouldn't say. But, I guess theoretically, if you got into an overpayment situation and they found that your SSI eligibility ended, but you kept getting it, then you might have an overpay situation with Medicaid. But I think as long as you're on SSI and you're getting ineligible for Medicaid, then I don't think it's going to be a problem. All right, Trish Wade is excited to see both of us. Well, good deal, Trish, from Tennessee. So I'm assuming Tennessee is probably a bit chilly this time of year as well, like it is here. JC Sports. I filed for SSD in July of 24. I'm 52, just had special second fusion of severe diabetic neuropathy. They approved my claim. Great. Did they change your onset date is the question here. I'm kind of getting the sense that's what you're saying. And let's talk about that a little bit, because this happens sometimes. What is your, Stephanie, how do you, when Social Security decides to change the onset date, how do you analyze that? What do you advise your clients?
It's very frustrating for them, for everybody. I'd like to take a good look at the date and see what they might have hinted upon.
Right.
I did recently have one where it was very unfortunate because it was a age 55 change. So they popped it on that. I really didn't think it was right. I thought the evidence really supported at 53.
Right.
And me appealing something like that is unusual, because I really go through the risks and the rewards with the person before they decide. And we did appeal this. It was I want to say it was a recon award.
Yep.
But he didn't like that onset. I got it. He got zero back benefits.
Yep.
He had to wait like 2 months.
Yep.
By the time, and we appealed it. And strangely enough, we got the decision like a month ago. It appeared to be a favorable.
Yep.
But it really just said the same thing.
Okay.
They gave the same
onset date.
I don't know why. I was like, why is that called a favorable? We appealed that. I don't know.
Yeah. Did you go to a hearing on that?
Yeah.
Oh, okay.
And yeah, unfortunately, so it ended up being a waste of a year to go to the hearing.
But your client got the money, was getting paid.
He was very, which brings up a point. As you were saying, Social Security is not that much relative to someone, particularly, not so bad if you were maybe a lower lifetime earner, but the people that really make a bit more, like a person who is heavy machine operator in New York City
Yep.
union. It's a hard nut to crack when
Yep.
when you're living on that, and then you don't get those back benefits, and you're living in a state that is very expensive, you
Yep.
know, and it's a tough adjustment.
Well, I mean, one of the things you just said is sort of part of when I talk to my clients. I don't think there's a huge amount of risk in general, because if they approved you early administratively, then, what is the likelihood that a judge is going to say you're not disabled at all? Now you get judged 15%, it could happen. But assuming you get a
Yeah,
reasonable judge, I don't think it's a huge risk. Again, most of the time, the worst case would be they just affirm what the recon, the adjudicator did, and you're, basically get the same thing you
no
otherwise
harm, no
would have got.
foul.
No harm, no foul. Every time I've appealed them, I've got 2 right now on appeal for that. I've won, and they've changed the
Yep.
onset date. So I tell my clients, look, the risk is you could be found, not disabled, and you're an overpay. So that is a risk, and you got to be prepared to, to assume that risk. If it's $3,000 or $4,000, probably not going to advise you take it. If it's $30,000, that's a lot of money, and you got to
Right.
really think about, do you want to do that? So,
Yeah. This one was like a risk, as risk-free as you could get with appealing.
Yeah.
Guy was over 55, but I've never appealed one that was ever. We always won the appeal
Yeah.
and got what we wanted.
Right.
But we've had colleagues, and I don't even recall who have had them reversed.
Yeah.
And that's why it's always like you have to, thoroughly
happen.
explain.
Yep. It could happen. It's not likely, but it could happen. And again,
Yeah.
Look, as attorneys, we are, we're giving advice based on, you've got to make the decision for you. Whether we get paid or not is not a factor. I mean, obviously we want to get paid, but at the end of the day, if a person decides to accept the changed onset date, this happened a couple months ago, it ended up there was no fee paid to me. I said, look, that's just the way it goes. Write me a nice review.
Yep.
Obviously, I'd like to get paid, but I'm not going to tell you to appeal because it benefits me. You got to make a decision what makes most sense for you. So I always focus on, the risk is here. I'm analyzing this. If you were, let's say, 49 and they changed the onset date to your 50th birthday and used the grid rule, I'd be reluctant to appeal something like that. If you're 54 and then they changed it to your 55th birthday, maybe you got an argument that, but again, to me, the risk there is that you get the same thing you otherwise would have gotten.
Right.
It's a case by case type of thing. You really have to look at it case by case, but you want to know why they did it, if there's any rationale behind it. Sometimes it seems kind of arbitrary. And look, there is the wild card out there is that Social Security is under a lot of pressure from Congress to save money and to preserve this trust fund. So I'm sure that they're given directives, if you can change the onset date to reduce past due benefits, do that, and I think that adjudicators sometimes are looking at, very rigid guidelines as opposed to a judge who's going to be looking at it more of a holistically. So I think it's just a case by case basis.
And there's been a lot of scuttlebutt about, just because people feel, I think, heightened experiences, meaning colleagues of ours, of more wins earlier, like initial and recon, but with a
Changed
less
onset.
favorable onset, and it has been a lot more, I think, and that's a little troubling.
Yeah. Well, I mean, look, on one hand, the old saying, a bird in the hand's worth 2 in the bush. So, if you're able to get on benefits and get some ongoing money, there is, to give you some peace of mind in your life, that's a positive thing. On the other hand, it's really not fair if you were truly disabled, a year and a half ago, 2.5 years ago, and they're just kind of arbitrarily cutting you off. That's not right either. So, you just, again, case by case basis, but it is very frustrating when you look at a file and this person clearly should have been approved 2 years ago, and now they're putting that person in a situation where you got to take that risk. So again, I'm looking at it in terms of, is it really a risk, or is it more like the worst case is you're going to end up where you are now? And if that's the situation, and they're prepared to take that risk, we'll go for it.
Right.
So yeah, he got $3,500, and maybe if the original onset date, he would have gotten $30,000. Well, you're looking at, another, 28,000 $28,000 makes a big difference. That's a lot of money. That's life-changing money in many respects. All right, RD is in Florida. It took literally 14 months for the initial decision onto the recon. Yeah, I mean, Florida, although it's interesting, I talked to a new client from Florida yesterday who applied in July and just got his denial in, in
November.
November. So being 100% VA disabled should put you at the top of the list. It's really surprising it would take that long, but Florida and Texas are really, really bad right now in terms of the time frame. But that is a long time. I would, certainly, if you're not represented at this point, make sure that you put on your appeal, I'm a 100% disabled veteran, and provide them with the VA rating paperwork so they know that, and my claim should be expedited. And if you're represented, have your attorney do that. It may be that somehow your file wasn't coded properly, which is very, very likely because Social Security is so overworked. But that's way too long. The other thing, look, I tell my clients, once you get beyond 5 or 6 months, don't hesitate to reach out to your U.S. Senator or U.S. Representative and say, do a congressional inquiry. Put pressure on them. You shouldn't have to wait, become homeless because you're waiting 15 months for them to make a stupid decision. Put the pressure on them. So that's what our elected representatives, what else are they good for? In many respects, not much, but I typically, I'll say contact your senator. And I've had good results with that. That's about the only thing that seems to move things along. Do you ever tell people to contact their?
I haven't right now, only
No.
because I know they don't have the adjudicators. And sometimes I'm like, it really depends. Like if they're in the middle of getting really important treatment that's going to add a lot to their evidence,
Yep.
I don't necessarily want them to rush the decision, because then they just lose that bite of the apple,
Yeah.
because
Good
they
point.
didn't, that MRI that's scheduled for 4 months from now,
Yeah.
or the physical therapy that's just going to start. So,
It's a judgment call. Yeah. I mean,
yeah.
you have to weigh on one hand not having money coming in for these extra months. And plus, there's no guarantee, of course. I mean, the congressional inquiry is going to do how much it's going to do. But yeah, it's a good point. If you have a bunch of tests coming up that could make a big difference, then maybe that delay could benefit you. So I think, again, case by case.
Yeah, or if they started their case, and I see this a lot, where they didn't realize how vigorous they should have been treating. And if you're going to rush your decision now on initial, when you haven't had the opportunity, now that you know you should be going to an orthopedist, not just your primary, or what have you. So.
Okay, makes sense. All right, Joel says, is it a good idea to accept telehealth or video call from behavioral health check, or better face-to-face? I'm not sure if you're talking about a consultative evaluation or just general mental health treatment. I don't know if I have an opinion on that. I mean, I think that, nowadays, telehealth is a lot more common. I get the sense that in mental health cases, it's not as necessary to be face-to-face. In a physical one where they got to, they need to do tests on you or take your blood or whatever, yeah, probably face-to-face is better. Look, going to the doctor is a good thing, no matter what type of doctor it is. So if you can get a telehealth visit that's either cheaper or easier to schedule, I'd say go for it. That's my take.
Agree.
Okay. Eric says, if you qualify for a grid rule, is an automatic win, or can a judge still strike a draw? Okay, there ain't no such thing as automatic in the Social Security world. So the grid rule is a shortcut. But if you look at the grid rules, realize that it's talking about, what is your residual functional capacity, which to some degree is a judgment call by a judge, and then transferability of skills. That is also a judgment call by a judge. So, now if you have no past relevant work, that's an objective. There is no, it's 0 or 1. You have no past relevant work. But the question is, what category is the judge going to put you in terms of your residual functional capacity? Sedentary, light, medium. Certainly when you're over 55 with no past relevant work, and you have, let's say, a herniated disc with, some evidence of radiculopathy or nerve root impingement, it's going to be hard for a judge to decide that you can do medium work. So I think that, in those cases, it's going to be a little more likely you're going to win on something like that. But again, a judge who's bound and determined to turn you down for whatever reason, they'll find a way. Now, maybe you can appeal it and you'll win an appeal, but, there is no such thing as automatic. I think that, and also I would tell you, even more so than saying that, when you're approaching disability, your case, you always go in with the idea, I don't want to be here. This is a last resort for me, as opposed to, I know I'm disabled, you need to pay me, you need to approve this case. It's automatic. Judges get real, I don't know what the right, just, they don't like that, okay? They get real concerned when somebody seems invested in the idea of being disabled. So I think that, you can make an argument, or certainly an attorney would make the argument, the grid rule likely applies here, and here's why. But at the end of the day, my client would much rather be working than not. And I think that attitude that comes through can make a difference for many judges. Would you agree?
I totally agree. I think when people think about automatic with a grid rule, I think sometimes they think, because I'm in the age frame when a grid would apply, don't I then win?
Mm-hmm.
And, it's not the case. I've had more than a handful of clients that are in the age frame where a grid rule may apply,
Right.
but they didn't know that the importance of getting that evidence of the physical limitations.
Right.
So that RFC is going to be either light or below or sedentary, and so that,
and also with the grids, it's not only applies with physical limitations. So you can't grid out on a depression case. Now, where the non-exertional, which is what would be non-physical, like depression, anxiety, things like that, where that comes into play is transferable skills. So if you are limited to, let's say, light or sedentary physically because of a physical problem, and you have a non-exertional issue, pain, poor sleep, whatever it may be, that may limit how easily your skills transfer. So it is relevant, but if you go in and the only problem you've got is depression, the grid rules do not apply at all. And that is something I've had to, I've had a couple of people just the last week, well, I beat the grid rules and what's wrong with that depression? No, you don't. And it's unfortunate, but the grids, it's still, I think there's a bias in Social Security in favor of people over age 50 and 55 especially, but the grids only apply if you've got physical limitations.
That's right.
All right. So, but yeah, I think you want to, and look, when we make an argument about to a judge in a brief, and let's say it's a grid argument, the person meets grid rule 202.06. They're 55 and over. They're limited to a light or less functional capacity. They have no transferable skills. I would still say in the alternative, I want to argue that this person's functional capacity has been so reduced by the combined effect of physical, mental, medication side effects, whatever, that this person would not be reliable at any kind of job. So you can make more than one argument. You could make a listing argument, you can make a grid argument, you can make a functional capacity argument all at the same time. I don't care which one the judge chooses, just choose one of them.
That's right.
And look, I've had cases that I think, because I track it, like when I get a favorable decision, if it's a grid rule case, I'll put that in my my case management system. I've had situations where I felt that the grid's clearly applied and the judge says doesn't apply, but I'm going to approve it on a functional capacity. Okay, that's fine. But you want to make as many arguments as you possibly can. Make the judge's life as easy as it possibly can be. That's my philosophy there.
Yep.
Okay. All right, Lachina, I hope I'm pronouncing that right. Lachina, I am nervous to speak to the adjuster. I have to call him tomorrow. Need a clarification with I don't know what do you know what Prolactinoma is? I'm not sure what that is.
That sounds like an impairment.
Yes. Now that we're asking, I don't feel like I should know. Okay, but let's see, Prolactinoma. Okay. It is a non-cancerous tumor in the pituitary gland that produces too much of a hormone called prolactin. So it's a pituitary issue. So, all right. So first of all, it's not the adjuster; it's the adjudicator. Just so our terms are right. Social Security uses adjudicator. They're kind of roughly equivalent to what a claims adjuster would be in an insurance situation, but the adjudicators work for the state where you live, and they are claims specialists. They're trying to make a determination: do you meet do you meet the definition of disability? That's called at the initial and recon is the administrative level. Then you go to a judge. My experience is that adjudicators are often overworked. They have way more files than they can possibly handle. They're looking for things like a listing level impairment. They're looking for things like a clear grid rule case. Don't be disappointed if the adjudicator turns you down. A judge is going to look at it much more holistically. So you're supposed to call them tomorrow. They need clarification about the doctor. I don't think it's, I don't ever hear, I don't know if you have, I'm not familiar with situations where an adjudicator will try to trick somebody. I mean, I think they're usually just trying to get information, the name of a doctor. I'll get calls from adjudicators. Is it okay to contact your client to ask them? Yeah, I usually don't have a problem with that. I've not had any situations where an adjudicator is trying to trick anybody. Now, according to this,
I have.
you have okay.
Yeah.
Well, then we have different experience. So,
Yeah.
what would you tell China as far as
Well,
talking to the
she doesn't
adjudicator?
have an attorney to make the phone call, so she has to do
Yeah.
it. But I don't think he might be asking about symptoms from her impairment, or is he
Okay.
asking who's your endocrinologist?
Yeah.
We can't figure out because then he needs to order those records, right?
hmm
Um,
Well, I mean, now here, and I'm looking at, and this is just Dr. Google here, but it says that prolactinoma is a non-cancerous tumor in the pituitary gland that produces too much prolactin, a hormone that stimulates breast milk production. Okay, so the question is, it's going to sound like a silly point, how is that disabling? Now, you could certainly see that being disabling, in certain customer service situations where, you might have to change your clothes more often. The question is, how does that prevent you from working? Maybe there's pain involved. Maybe I don't know. I'm just saying, but at the end of the day, the condition, like I have, cases, and we all have cases where people have irritable bowel syndrome, or they have some problem with excessive urination, and they've got to go to the bathroom frequently. And, my experience has been usually pretty good with those cases because adjudicators and judges realize if you're taking unscheduled bathroom break every 30 to 45 minutes, that's going to be really hard to maintain competitive employment. Maybe that's the same thing here, that if you have to go to the restroom to clean up, to express breast milk, whatever the case may be, or if there's other symptoms, that may be something that would cause too many unscheduled breaks. But that's the way you want to approach it. You don't win based on a diagnosis. You may have a pituitary tumor and it causes this problem, but how does that translate into a work problem? And that's what you got to really focus on. So I would say if you're not represented and you're talking to the adjudicator, and you get uncomfortable with the questions being asked in the phone call. So, I'm going to get an attorney. I don't feel comfortable talking about these things. I get the sense I may be, talking about things that I don't want to give you incorrect information.
not explaining it right. I feel like
Yeah.
I'm not explaining it to,
Yeah. You're not on trial for anything, realize, and you have the right to, to say, I want to get an attorney to get involved. But I think that if you do decide to talk to the adjudicator, keep in mind that the main thing that is going to move the meter in your Social Security case is how does this condition prevent me from being a reliable employee? And again, the things that come to mind, I may be completely off base here, unscheduled breaks from work to go to the restroom, need to change your clothes. Maybe it's painful, and that causes problems with focus and attention and concentration. That's what I would say. Okay. All right, Eunice Sela. I'm 54 years old, worked 30 years, severe pain in the cartilage of fourth and fifth vertebra. Now the pain is unbearable. What are my chances? Um, Steph, you want to take this one?
Yeah, let me just read it.
Okay.
So would that be the upper back?
Well, fourth and fifth vertebra, I'm thinking it's probably thoracic spine, maybe,
Yeah.
or the cervical. It's either
Up,
thoracic or
higher.
cervical.
Yeah.
Yeah.
Wow.
Well, I would
So
think. Go ahead.
what's the diagnosis? I mean,
Yeah, right. What, right. That's the first thing I was
for
going to say.
starters,
Yeah. Have you had an MRI? You know, do they know exactly what is there a disc herniation? Is there a bulging disc? What is causing that pain? Is it some sort of you know, connective tissue disorder? What is causing the pain? Because again, you go to Social Security and you say, I've got pain, you know, there needs to be some sort of a level of consistency between the diagnosis, and the level of pain you're experiencing.
yeah.
So I think
Diagnostics are going to be so important.
Yep, yeah. Because pain, look, I mean, pain, you know, I read some study that, you know, a certain percentage, I mean, I don't know, 7-8% of the population has disabling pain at any point in time. There's a lot of, you know, millions of people. But, you know, in the Social Security world, if you have pain that is not tied to anything in particular, you know, the fibromyalgia type of situation, you know, kind of a pain syndrome, those are tough cases because, you know, judges look at it and say, well, what's causing this? And am I going to pay you? Am I going to prove your case because you say you're in pain? It's a lot easier when there is a diagnostic test that shows a disc herniation, a tear someplace, something that is consistent with the level of pain you've got. So I think, Eunice, the first thing I would tell you is, what is the diagnosis, and is there any objective diagnostic testing that can be done to kind of correlate your level of pain with the underlying medical diagnosis? Right, that's my thought.
Nerve impingement,
Yeah,
stenosis,
could be a lot of things.
canal stenosis.
Yeah, and I think the other thing I would tell you is, you know, keep a pain diary. You know, what things trigger the pain? Is it something that, you know, if you have a very physical job, you know, might you be able to do a less physical job and it would not trigger the pain? You know, so there's just a lot of things, but I think the initial thing, both of our reaction is, what's the diagnosis? You know, you got to be able to know why you're having this level of pain. Just having pain without a diagnosis is
Got to really get it worked up.
Yeah.
On the medical side.
Yeah. I actually had an interesting pre-hearing call today with a client, and this is a mental health issue, but he made a very interesting point to me, and he's got, he took a medication, has long-term side effects from it, and in his situation, you know, the condition is causing him, you know, a lot of depression, anxiety, poor sleep, a lot of the stuff. But he goes to a psychiatrist who basically doesn't speak English, is not his first language, and the psychiatrist's notes say, you know, says he's doing better, doing fine. And so I told him, I said, this is going to be a problem. He's just like, well, basically the doctor told me the only thing I'm going to be able to do is give you a medication to help you sleep, you know, or a psychotropic medication to kind of, you know, make you, you know, to deal with the depression. I'm not really looking at anything else. And so he's like, this is not an accurate representation of what's going on with me. So, you know, it's going to be a tough argument, but it's an interesting point. He's like, you know, every doctor, they have their one thing that they focus on, and you may have a problem that is not within that person's focus. In this case, he's got migraine headaches. Okay, you got severe migraine headaches, but, you know, the neurologist that he's seeing does not deal with migraine headaches. So, you know, what do you do? So it's a, you know,
got to get a migraine neurologist.
Yeah, that's right. You get a migraine doctor, migraine specialist. But, you know, if you don't have insurance because you're not working, that's hard to do. You know, so sometimes that can be a real issue there. But, you know, my reason made me think of this was that, you know, you've got to go to the right kind of doctor to find out what's going on. You go to an orthopedist and maybe there's no disc issue here. So maybe there's something else. So you got to be your own advocate and find out what's wrong with you. So I think that's part of the challenge. When if you don't have a lot of money or a lot of insurance, that's a real issue. Okay. Carrots, is being 50 or 45 a difference when it comes to approval? Yeah, I think so. I think a big difference. I think that at 50, the grid rules apply. I think there's a bias in favor of people at 50, and it's a lot more difficult at 45.
It's worlds apart.
Yeah, it really is. It really is. In fact, it'd be interesting to know. I don't know if you've ever seen statistics. What is the approval rate for people over 55 versus people, over 50, then over 45? I mean,
Yeah,
it'd be interesting to know.
it's funny they don't, as far as I know, they don't publish that.
No.
And that annoys me.
Yeah, well, because what they do publish is something called a waterfall chart. Comes out every year, and it tells you what percentage of cases were approved at initial, what percentage were approved at recon, what percentage were approved at hearing, and you kind of see, a number of years ago it was like 60% approval at hearing, then it went down to like 42% after the Eric Kahn nonsense. Now it's kind of inched back up. I was like at 50, now it's at 48. So every year it kind of, varies within a kind of a range, but it would be really interesting to know what the percentage is of people over 55, because they know it. It's just
I would
they're
like
not
to see
releasing it.
I'd like to see the 20s, the
Yeah,
30s,
yeah,
the 40s.
yeah,
How about up to 45? And then, how isn't there, it doesn't seem to be in real life, but there's some rule about even, how we have the close to 50, they can,
yeah.
if you're within a few months of
Right,
an
you
age
can use the
change.
grids, right?
There's
The grid
something
framework.
also about 45 to 50,
Mm-hmm.
but I've never seen it play out.
No,
Yeah,
no.
have you ever seen it where they can? It just doesn't seem to be one that they actually use.
No, well, I think that, there's a lot of talk in the Social Security world about Social Security using AI as a way to evaluate cases. Now, I will tell you, looking at some AI engines that are available, to us to analyze medical files, we're a long way from that. But the point is that, you give me a fact pattern, a 56-year-old with a herniated disc and nerve root compression, I can tell you that's a pretty strong case. A 45-year-old with a bulging disc, no nerve root compression, mild depression is probably not going to win. So, there are certain profiles that we just kind of know are going to win. And I suspect that could be probably part of an AI, analysis that Social Security may start using more to kind of take the, to deal with the adjudicator, the problems with personnel, because they got a real personnel problem. So I wouldn't be surprised to see that coming down the pike at some point.
I wouldn't either, but it's a little scary because if the AI is going to be making the decision,
Yep.
whoever programs that,
Yep.
they're going to err on the side of
Right. Not paying you.
denial, I think.
Yeah.
And you don't have the initial and recon. I don't think it's going to matter too much.
Mm-hmm.
But if it's at an ALJ level,
Yeah. Yeah.
would it even be at the ALJ level though?
Well, I mean, I think that the goal, what I've always read is the goal is to find, they always say the goal is to find the cases that should be approved early and get them approved early, which sounds great. And obviously people that should be approved early, should be. But that also, and the flip side of that means that if you're not approved early, then, you're probably going to get denied and you're going to have to end up in front of a judge. And so, is it going to be a mark against you that you didn't get triggered, the AI engine didn't catch you early? Or so I don't know. It's really very interesting, what they're going to try to do. But, I know that they have a real problem with staffing. They don't have enough people. And, they would love to use an AI engine to, make these determinations without involving people. Now, of course, the unions will have something to say about that. But, the thing I keep hearing, right or wrong, is that Social Security, that Congress sort of wants to starve the disability program by not providing enough people, and therefore the delays get so ridiculous that people give up. Maybe that's a cynical way to look at it, but that may be what we're dealing with. So, It's going to be challenging times, no question. Just Jake, 58, no longer able to work in law enforcement due to flat feet and PTSD, 100% permanent total with 7% PTSD and 50. Do I use the grid rule? Well, I mean, again, the PTSD is not going to be a factor in the grid rules, and the flat feet, let me see what 202.02 says. So you're going to be in the light grid, 202. You're 55. It says limited education, no transferable skills. So the question is, Jake, are you limited to a light functional capacity? Will the flat feet be enough to do that? I don't know. Are you, it says limited or less, which means less than a high school education. So I'm assuming that's the case here. The PTSD would limit probably transferable skills. My guess would be there's probably not a lot of transferable skills out of law enforcement to a sedentary type of job. The real question in my mind is, how do you get yourself to that light RFC? How do you convince a judge that your capacity for work is no more than light? And again, maybe the flat feet would be enough. But do you have something from your podiatrist or your doctor to say that you can't stand, 6 hours in a day? Is what it's going to kind of boil down to. Is what I'm thinking.
I would also suggest at 58, I'm right there with you, Jake.
Yep.
I always tell my people, hey, look at, I have a body chart, and I'm like, consider your body, front and back, and what body parts are not like they were when you were 20. Because he's talking about why he's not doing law enforcement, so he's focused on the flat feet and the PTSD. Clearly, that would be important for law enforcement. But they're at 58, we might have other aches and pains. How are your knees, your ankles? How's your neck? Do you have any tinnitus because of maybe gunshot?
Yeah.
Don't forget about all those other impairments, because they can make the whole difference.
Can make a difference. And look, the PTSD, so not only the grid rules, but, remember that functional capacity argument, PTSD, what are the triggers of the PTSD? Is it loud noises? Is it certain people? Is it being in a confined space? I mean, that can also be, an argument, beyond the grid rules. And that can be part of the non-exertional part of it, where you basically explain why your skills would not be transferable. Maybe the sound of a printer, or who knows what could be something that could cause trigger you. So somebody says we got a little echo. So I just turned, maybe it's coming from me. I just turned my sound down. So let's see if
Can
that
you guys?
helps.
Yeah, ask them if me.
Okay, so
If
Ryder Dust says the woman has echo. So
the woman has echo. Like, how do we do this?
I don't know. I mean, you've got, this is the second. I don't know. I mean, I'm using a little lav mic here, but again, I'm not. I'm not using a headset. Maybe I'll try that the next time, because I'm using like a my computer speakers, so they may be echoing back into my microphone.
Well, but it's coming from me, not from you.
I don't know, unless the echo from your echo from your talking is being picked up by my microphone, but I'm going to turn it down more so that I can hear you enough, but it's not very loud. Let's see if that helps a little bit. Zippy, I'll be 60 soon. I became disabled in 21. My ward says CDR 5 to 7 years. What are the chances? I don't think very great. I mean, you're 60. They're not going to focus. They're focused on 35-year-olds. Not people who are close to retirement age. I don't think. I don't think.
Yeah. So 3 years ago at 57, will they give it to him at 62?
Yeah.
I think it would depend on if they're backed up or not. It's going to depend on so many things, and it would probably be a short form. So
yeah,
you
I
just
would think so.
keep, which means they're not even really going to get to a full blown CDR, but
Right.
just make sure you keep up with some semblance of decent follow up.
Yeah, go to the doctor
with all your stuff,
right.
So that your short form, they're like, don't think it's going to happen.
Yep.
And then they just keep on going.
I would agree.
Nothing to see here.
I don't think it's very likely at all. Okay. Um, Getting ready to turn 50 on a 7-year CDR cycle, been a disabled adult child benefits since the age of 16, went through a short form CDR. If they've reviewed you in the past as below 50 and they haven't cut you off, probably not likely they're gonna. I mean, assuming you've got something fairly significant, I don't expect that you're gonna have a big problem there. Again,
And again, just make sure you have those basics
yeah, you keep
kept
going to
up
the
with.
doctor. Keep going to the doctor. All right. So No Sky says get a free case evaluation. Very good. Um, yeah, I've never seen that. I don't know what that is. 3 little boxes there. Okay. How long to wait for an initial decision? Will be required to pay the new fee since it's gone up. Okay. A 2-part question. I'm telling people 8 to 12 months for an initial application most places. Could be a little bit less if you're 100% VA disabled. Then it could be a little faster, but it's going to be that way. As far as the new fee, yeah, any decision after November 30th, basically the 25% remains the same, but the cap went from $7,200 to $9,200. So that is applicable for all cases decided after December 1.
And be mindful that I don't know what the percentage breakout is, but many, many cases never hit the cap.
Right. Right. I'd say,
Even at the 7,200,
yeah,
like,
many
so
cases they're not. Right. I think
most
my
people aren't even
average.
affected by this whole thing.
Yeah.
I
Yeah.
mean, we
And,
like
and
it.
look, I mean, we have part of the problem. Obviously, is these cases take a long time. There are, I've had people say, well, you want it to take a long. I don't want it to take a long time. I want the cases to get approved and moved on as quickly as possible. But, and again, I'm not apologizing for earning a fee in a disability case. You got a case in your office for 2 or 3 years. That there's a cost involved in that. You got staff people dealing with it. You answering questions. The cases. There's work involved in it. So again, they have been. It's really interesting. It was stuck at $6,000 for like 15 years. They changed it to $7,200 a few years ago, and now they changed it again and gave us a cost of living, which I think is long overdue. So again, I don't apologize for earning a
No,
fee in this. So,
truly. And I think we were bleeding qualified representatives
yes, that's true.
because
I would
people
agree.
couldn't afford to do this kind of work. People
Yep.
couldn't afford to get into it. I mean, you and I have been doing this for a long time,
Yep.
so it was probably easier for us. But for the people just starting out,
Yeah.
it was,
And again, I don't like, talking about, people hear me complain about the business part of it because that's really not their concern, and nor should it be. The point simply is this: if you are an attorney that you wanted to get into Social Security disability, and I do a lot of continuing legal education trainings, I tell people, look, you're not going to see a dime for 2 years, so you got to be able to support yourself with some way, shape, or form, with some other type of work until you have the cases start to get into that hearing cycle. So the problem was when the fees were kept artificially low, in my opinion, for all those years, people that did this stopped doing it. I know a number of people who just said, okay, I'm done. I can't afford to do this. My costs have gone up. And so, you get less qualified representatives or people that can't find representatives at all. And look, quite frankly, I think, and again, I don't think this will ever happen, but there really should be a sliding scale where, because as we talked about, people under 50 are having a much more difficult time winning, that there should be a higher fee available if you're for a claimant under, let's say between 40 and 50, and an even higher one for between 20 and 30. Nobody has to have an attorney, but attorneys are going to be really reluctant to take, if you have 5 cases in front of you and one of them is a 25-year-old and the other 4 are 50-year-olds, you're just not going to take the 25-year-old because the odds of winning are not great, and you don't get paid anything if you don't win. So
right.
it's Social Security in some ways discourages people from getting attorneys, like they do with the CDRs. Where if you choose to have your benefits continue, you can't get an attorney. And I think
Yeah.
Look, I interviewed a guy named Spencer Bishens on my podcast. He's like, this is all intentional. They want to prevent people from getting attorneys. They don't want people to have representation because it's easier to turn those people down. So,
Yep.
okay. So Rodney tells me, okay. Yeah, Rodney is one of our clients, and what they do is they do an audio recording and they do it in this OGG format, which no one's ever heard of. And, if you have the utility on your computer, you can convert it to MP3. So I took his audio and I converted it to MP3 and sent it to him so he could listen to his hearing, which is actually, let me just say this. If you go to a hearing, ask your representatives, get a copy of the audio, listen to it. You'd be surprised. People don't remember, it's hard to remember lots going on real quick. Get a copy of it. Get a copy of your exhibit file. You want to be your own advocate here. So you want to have your exhibit file and the audio so that down the road, if you have to listen to it again, you need to know you got it in front of you. I think I would recommend it.
And I think it's very hard for a claimant who doesn't know all the terms of art that go on in a hearing and the relevance and being able to remember what was said when you don't actually know what that meant is going to be all that much harder. So if you can listen to it later, it can be.
Well, I mean, I remember I have a case now that it's on appeal at the appeals council, and the client said to me, the judge asked the vocational witness one question, and the one question got a response, there are no jobs. Like, okay. And the judge turned it out. I'm like, that makes no sense. Okay. I listened to the audio. The judge asked the vocational witness 5 questions, not one question. One of those questions got the answer, no jobs, but the other 3 of the other 4 of them, there were jobs. And I'm not blaming the client. It's just that it's hard to, if you're so focused on what you're trying to say and just the ongoing speed of the hearing, you may not remember. So that's another reason I think you should listen to it to sort of hear what's said. Listen to it a couple of times, and it could be very, very enlightening.
I hear that a lot when people, and I'm like, well, if there really was only one hypo and there's no jobs are ever mentioned. And no jobs available, and the judge closes out the hearing, I think it sounds very positive. But again, like you said, it's like eyewitness testimony. Sometimes it's the worst in terms of the detail, right?
No, what you're talking about that is that, and again, this is a little bit beyond Social Security, but there have been studies done where you'll have, let's say, a scenario set up where you have 10 people that see something, it's in a stage type of thing, and you ask, what color shirt was the guy wearing? How tall was he? And you get answers all over the map. Look, there's that ridiculous murder today. The head of United Healthcare gets blown away in Midtown Manhattan. How many thousands of people are within 100 yards of this? And I guarantee you that there are going to be people that say, "Oh, this guy was 5'3", and this is 6'3". He was riding a red bicycle, a blue bicycle." I mean, you just don't really know. And so, it's eyewitness testimony can be, whether it's you or whatever, you just never, you'd be surprised how often your mind kind of fills in the gaps, and it's
just
not
human
exactly
nature.
accurate.
I always go back to My Cousin Vinny, funniest movie, and it's all about the inaccuracies of eyewitness testimony.
Exactly. I've seen these videos where they have they ask the person, okay, focus on this. Then you got a person in an ape costume dances across the stage. They don't even see it, it's like because they're so focused on one thing. All right, enough of that nonsense. Okay, Lulu says, I'm 61, have applied for SSD. Can I get my regular retirement waiting for decision? What could happen? Okay, that's a very, very good question. The answer is yes, you can apply for early retirement where you give the government the discount, and then if you get approved, they'll bump you up to full retirement. So yes, you can apply for early retirement while you're waiting for disability to be processed. Now, the one thing I will tell you is, you may have a difficult time getting an attorney because, again, we're paid a percentage of past due benefits. In this situation, if you're taking early retirement, we get the difference between early retirement and disability or full retirement. So let's say that your early retirement is, let's pick a number, $1,500, and your full retirement or disability is $1,900, that's $400 a month. So our fee is going to be 25% of $400 a month times however many months you have to wait. It may not be a whole lot of money. So, some attorneys, I look at it, and if the early retirement amount is, let's say, $900, that's telling me that the full is going to be maybe $1,200. And again, you get my Social Security statement. I may not take that case. It's just because the amount of work I'm doing is the same for another case, but to do a lot of work and get a fee of $500, it's probably not worth it. So this is
It's
again
like a
another
pro bono,
situation.
it won't cover your costs.
Yeah,
It-
yeah,
it-
that's right.
Um,
Look, I know you're kind of a solo, but I've got like 5 people, and they're all getting paid,
Overhead.
and which I'm cool with. But I've got cases where I can support that staff, and even as a solo, your time is your money, and the time you spent working on, I don't know if you've got any part-time people, but the
Part-time.
time you spent
Yep.
working on case A, you can't work on case B. So if you're going to earn $800 on case A and 6,000 on case B, obviously you know what's going to happen there.
Yeah. One thing also, just for Lulu, just remember too, I mean, I know you're probably thinking of taking the early retirement because you have to, or for whatever other reason. There's a multitude of reasons that everyone's life is different. If you don't prevail on your SSD, you are stuck with the early retirement
Yep.
and the discounted amount of your forever retirement for the rest
Right.
of your life.
For the rest of your
So,
life. That's
so
a
you have
very
to
good point.
be willing to that risk right there. I mean,
Yep.
but sometimes you have to do it,
Yeah.
or you choose to. People have a variety of reasons, why they would, good reasons. But just know that you might, if you don't prevail on your SSD, you could be
You're stuck
stuck
at
with
the
that
lower
amount.
figure. That's
Yeah.
exactly right. That's exactly right. Okay. Writer dust. I got a letter off SSDI now at SSI because I turned 65, 90% disabled from the. No, that doesn't make any sense. You may have gone to Social Security retirement, not SSI. You don't get kicked off SSDI and go into SSI. They typically move you from the SSDI trust fund to the retirement trust fund when you hit full retirement age, but not SSI.
Which is
SSI
not 65 either, though.
it's
Full
going to be
retirement is not
66 typically.
65.
Yeah.
It's 66 and change, right? And
Yes,
then
correct.
about to be 67 very soon, I
Yeah,
think.
yeah. So that doesn't, a lot of people use the word or use the term SSI kind of as Social Security, but SSI is a very specific type of benefit. It's a means tested disability benefit. So if you're on SSDI, it means you had enough credits, you would not lose access to your credits. So you remain on SSDI. I think I'm guessing you mean early retirement or retirement. Can the 5-month work period? All right. So I think what you're asking is, I mean, it doesn't really offset it. I mean, basically what you're saying is, can you use your trial work period before you're approved? Yes, you can use it as of your onset date. So if you were working, let's say that your onset date and let's just make your application date, your onset date, January 1 of 2023. And so you don't get paid for January, February, March, April, May. You start getting paid SSDI in June. So if you were working and over trial work but below SGA, yeah, you could certainly use that trial work period during that 5-month period of time, if that makes any sense. So yeah, I will say this: I've had a number of judges approve cases where the person had work, and they use the trial work period to allow that person to get more benefits. If you're over SGA, which again is a different number. So remember, in 2000, I'll use 24 numbers. Trial work period's 1,110, SGA is 1,550. You apply for benefits, you're earning $2,000 a month, okay? And you're saying, I became disabled January 1, but you're earning $2,000 a month. I don't think you could really use your trial work period for that period of January through, May. I don't think that's going to work. I think a judge is going to look at it and say, you're earning over SGA, therefore your disability would begin after you stop earning SGA.
Unless
Okay.
unless he had an earlier, let's say his onset was in November, he was out of work for 2 months, he had an unsuccessful
Work attempt. Okay.
work attempt, then
Yeah.
But it sounds like he's asking if it can be used to offset the 5-month waiting
Yeah.
period. It's not a positive thing necessarily to have used it up. So, I mean, we don't like the 5-month waiting period, even though it's a necessary
Right.
evil, but using up 5 of your 9 trial work months, you got to pay attention to that. I would
Yeah.
pay attention to the trial work period and
Yeah. Yeah.
hopefully not
But
blow through it.
the big picture is you can use your trial work periods before you are approved after onset.
Yeah, you won't know. You won't know for sure
Right.
because it's all going to depend on when you applied and when your onset is. If it's way later, then it's never going to be part of your. It's
Correct.
a freebie. You got to work it, and
Correct.
but you don't get.
Correct. I mean, I will say this big picture. I've always felt that Social Security tends to see things kind of in black and white. And so when there's a lot of work activity around the time of onset, many times they're going to just want to move you to the point where it's after you've worked. I mean, it's hard. An adjudicator is not going to find you disabled when there's a lot of earnings. A judge might, but it's it's going to be a little more iffy. But I mean, conceptually, the answer to your question is yes. Realistically, maybe, maybe not. Okay. Like it is. Hello, like it is. How are you doing? St. Louis. Under what circumstances would an ALJ bring a medical examiner to a hearing, a medical expert? What are the best practices for claimants and attorneys when an ME is at a hearing? Steph, take it away.
I think it's when sometimes if the ALJ wants to determine if it's a listing,
Mm-hmm.
and maybe that wasn't addressed well below, or if he doesn't really understand he's not really feeling very confident in his understanding of the medical condition.
Yeah.
Yeah.
Or it's a very complicated medical record.
Yeah.
So I mean, that's generally, I would say there's some ALJs, and you don't see this much anymore, but in the past, there were some ALJs that got medical experts on every case. They just did it. But I think that Social Security doesn't want to do that because it costs money. So my experience has been that they will get an ME, they call them an ME, on cases where the medical record is really complex, or as Steph says, that there is a possible listing level thing going on there. As far as best practices, it's hard to, I would say this, there's a lot of discussion on the NOSCR, listserv, what do you know about this particular doctor? And so, if the doctor can be cross-examined because it's not his or her specialty, let's say they bring in, I remember years ago, they had this retired pediatrician who came in, and she wasn't actually a bad medical expert, but she'd come in and she'd be talking about kidney issues. Well, you can object to that. You can say, well, doctor, when's the last time you did any sort of kidney treatment? Never. So you can go after them that way. I'm not of the school that thinks that attacking medical experts is going to really do you a lot of good. My experience is judges are going to listen to what the medical expert says. I'll ask, is this within reasonable medical certainty that the symptoms that the claimant is alleging are consistent with this? They'll usually will say yes. Some medical experts are very, very, conservative in terms of how they assess functional limitations. Some of them start to go into, coming up with functional capacity statements. And I'll say, what training do you have in doing a functional capacity assessment? Stuff like that. But you have to I think you got to tread lightly. That's my feeling as far as the attorney side of it.
One thing I would also add, I think if you know your evidence really well and you know where to find it in the exhibits, the pinpoint citation, and you could ask him about a particular thing in the medical record that maybe doesn't seem like he's addressing.
Right.
I did it once and it worked out great, and it was with a very hostile judge. And we ended up winning, and it had to do with migraines and headaches, which can be a doozy.
Mm-hmm.
And the only thing I could really do was I pointed out the statements in the record that the treating, neurologist that treated the person for the migraines would note about X amount of migraines, and da, da. And then asking about, if I recall, and this is a few years ago, asking about, if a migraine causes nausea, blah, 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 would that be something that you would expect him not to be able to show up for work at, as a doctor? Would you say he should be in bed or whatever? But that was specific to migraines. It can be, I think, probably much more difficult with some other things. But I would probably try to have those pinpoint citations, you know what I mean,
Yeah.
ready to ask him about, and say, well, if you see if you see the medical record with this,
Mm-hmm.
what would you say? Would that
Yeah.
be, and it worked. I mean, he ended up, he was awesome. The ME, the judge was, like I said, very unpleasant, but it all worked out in the end.
Yeah. No, look, I've had judges, basically discounted ME. They just say, I just didn't feel the ME was, gave an accurate assessment. So it can happen. And again, some of
Yep.
these MEs are, they are retired doctors who are looking to make extra money, and they like to hear themselves talk, and they think they know everything, and they are hostile to disability. So yeah, I mean, it can be a challenge, because I think judges are going to give a certain amount of deference to that doctor. And, of course, you could ask questions, well, you've never examined this person, correct? So, there's lots of ways to do it, but, you don't have a lot of time. Just have to sort of kind of figure out what's in that particular case, do your homework and be prepared for the ME as best you can. But, I think, attacking methodology, attacking specialty, things like that would be a way to deal with it. And again, it may be something where you have to just set it up for appeal,
Yep.
because the judge is not going to give you a lot of time.
Yep.
All right. So Elle says that Strasbourg is in the mountains. That's big. So do you have bears around where you live?
We do.
Uh-huh.
I don't see them as often as I would like to, but occasionally my ring will catch one
Okay.
walking across or getting in the garbage. But some places in my community have way more bear activity than.
Okay. Well, you can have the bears. I'm not a big, we go up to the mountains in North Georgia, and my wife said, let's go take a hike. I'm like, no, I'm not going hiking in bear country. No, I don't think so. I'm not that fast. Anybody who's seen me play tennis.
You just have to be faster than the other person.
Right. But I'm afraid my wife, I think my wife's faster than me anyway. But I'm not going to leave her behind. So, all right, Ms. Alexander. Hello, everyone. I wanted to know if it's normal for Social Security to reach out to you confirming your hearing date. How long do work credits last? I've worked since 2022. They typically will send you an automated voicemail. Typically, they're not going to call you. It's going to be automated. And work credits, assuming you've worked full time, it's going to follow you about 5 years after you stop working, because 5 out of 10 years, generally speaking. If you're younger, it could be less. But if you're in your 50s, let's say you stop working full time, it's going to follow you for about 5 years.
And that's assuming you worked the 5 years leading up to when you stopped, without
Correct.
a full year of gap here and there and all that.
Correct. So Garrett say you can't pump. That's correct, Garrett. You cannot pump your own gas in New Jersey. You go to a gas station, it is required to do full service. And obviously there's money changing hands there, but only state in the union like that.
Very interesting.
Okay, well that's great. You got yours. Well, that's very, very good. I'm glad you won. That is why we do this. Okay, Vincent, one of my clients, about 28 and some light snow. 2 hours west of you, expecting 7 to 10 inches. I think are you not in Chicago? I think you're up in the Midwest, if I remember correctly. Yeah, that's you can have it, man. That is a little too cold for me. I do not want. I would like to see, like, one nice snowfall. That would be kind of cool. One nice snowfall that would last a couple of days, and then that would be it. But we haven't really had any snow in Atlanta in the last, I don't know, several years. We get these ice storms periodically where it knocks down the power, but we don't really
Yeah.
get so much snow. Now, in 1993, we had a blizzard. That was the year my son was born. And we had a blizzard, and that was pretty crazy, but nothing since then. All right, so I'm sure Garrett's going to ask me to do this. I'm going to go ahead and do it for a case evaluation there. Okay. Okay. What, let's say the sacroiliitis, that would probably be listing 1 because it's a musculoskeletal listing, if I'm not mistaken. and go to meetalisting.com. You can link to the listings there. All right, Stephanie, I got to ask you because I get these questions a lot. People, I'm at step 3. Does that mean anything? What is step 3?
This is what I say to them, because it depends on what step, because they're getting these messages through their online account, oftentimes on their phone from SSA, right? So because step 3 would not be like, okay, so she's at the adjudicator's office. So are they referring to step 3 of the sequential evaluation process?
I don't think so. I think
I don't think so either, because needing to clarify my job, wouldn't that be step 4?
Yeah.
In the SEP?
I think that what the people see, we don't see it, but people see on their My Social Security when they go online, your case is, maybe they still do it, is, 65% done, or you're at step 3 of the process. I think these are just made up classifications to make people not upset. I don't think it means a damn thing. Is my
Although I will say this, so Meathead asks, the adjudicator said I needed to clarify my job title and even gave me suggestions on how to word it. This is like pivotal right here, I think. They only do this when it matters. The step 4, they think it could be he could win at step 4. So if you have an adjudicator that's not trying to stick it to you,
yeah, that's good. That's good.
Then he could be helping you, but you don't necessarily know. I mean, you're 55. This is when this stuff is so pivotal, that particular work thing. This is why I think the work history report is so important to get it right. And maybe when you did your work history report, it was the old version versus the summer of 2024 new version. And sometimes they want all these more details that they used to have to call about. And that's probably they're probably reaching out, because you probably, when he did his, maybe Meathead, when you did your work history report, it was before June, right?
I think so.
Yeah, but
and just I would also say with regard to jobs, job title is not as important as what you actually did, and you really want to think about what you did. Don't overstate it. I mean, I think sometimes people, they think about, okay, what's the, I had a day where I had to lift 100 pounds. How much did you lift? 100 pounds. No, you think about it in terms of an on average day, what you did. And so, you want to be accurate as you possibly can, but don't exaggerate or understate what you did. Just try to be as accurate as you possibly can.
I would agree, except for the frequent, what did you lift frequently? Right? The 2/3 of the day or the half. Sometimes that's going to be a really low number.
Yeah.
But if you do have to lift 100 pounds on occasion, I would really drive it home, because
absolutely.
Because that's what's going to
completely agree. I mean, that was probably a bad example, but yeah, right, because that shows you had to do, a much higher physical level. That with the grids, that's going to make it easier to meet the grids. My
but
point
though
is that think about what you really did. Like I give you a perfect example. I get people. This is probably a better example. I was the manager. Well, didn't have a manager title. You didn't do hiring and firing. You weren't doing reports, but they gave you a title so that you wouldn't ask for more money. Or I did everything there. Well, maybe, but that wasn't really your job, your obligation. Maybe you did stuff, but you want to really limit it to what you were hired to do, what you actually did.
Because the whole thing, guys, about being a manager of people. And I think it's also really important, because if you're a manager of people, they're going to try to make that a transferable skill.
Yes, that's correct.
Right. And I always try to make sure we figure out, well, how often if let's say someone was a supervisor, how often in that day, how much time did you really spend hovering over your people? Or was it hey, let me take attendance, y'all 5 here? All right, let's hook up again and see where we're at noon. So where you could actually say, well, about 35, 40 minutes a day, I supervise them. You walk through, you make sure, because that's going to be important, because then you weren't full-time supervising. You were doing your own job
you're working supervisor.
Your seniority got you the The
Yeah.
lead work, but almost like a lead,
Lead
what do they call it?
worker.
A lead
Right.
worker was the word they used to use. I don't know if they still use that with the new form, but that was not so bad if you were a lead worker because it meant you were kind of like a working foreman. You're in there doing the job too. You just happen to have more seniority and know what you're doing compared to the new guys. But if you say that you supervise them all day long when you really didn't, that's going to hurt you.
Yes. Right. Because
You
right,
know,
supervisor, especially hiring and firing, that's going to
yep,
assume transferable skills, which
yep,
basically could go to a lighter type of job, which again is going to make it harder to meet the grid rules. Is
yep.
is really what's going on. All right. So lumbar facet. Basically, it's arthritis. It's not. I don't think it's a listing. It's not going to be listing level. That is lumbar arthritis. To meet a
Musculoskeletal.
listing for musculoskeletal, you've got to really almost be unable to walk. I mean, they made it really, really hard.
Like, yeah, like two canes or
Yeah.
two, you know.
Okay, Eric. She doesn't use the grid rules. I'm not sure what you're asking, Eric. I don't know. I mean, you always use the grid. If the person's over 55 and there's a physical limitation, you look at the grid rules. You always want to try to use it, but you got to look at it both in terms of the physical limitation, the age, the education, the transferable skills. So you can, but yeah, but if all you have is depression and anxiety, you can't really use them because there's no limitation of the person's residual functional capacity. They could be, able to do medium to heavy work. And if they do that, then the grids don't really apply.
Yeah, I mean, you could always take anyone who's 50 and be like, well, let's see, do you have impairments that would allow us to use the grid rules
Right.
and push for them? And that's
Yep.
that's always kind of a goal. That's why I'm always like, yeah, I know you left work because of severe depression, but come on, you're 56. Are you sure you don't have something wrong? Like, is your body like it was when you were 20? Even if it didn't take you out of your job, your depression did. And that makes such a difference because then we can use the grid rules.
Correct. Correct.
The
And
judge is
look, I
not
mean,
going to
if
use the
you
grid
are,
rules on you if you don't.
if you're a 4'9" female, 4 feet 9 inches tall, you weigh 95 pounds, even if you don't have a back problem, I suspect that you could probably get a doctor to say you can't reliably do medium work, right? You're not going to be able to do lifting 50 pounds on a frequent basis. So, even if you don't have a medical problem per se, if you are very, very small,
I've seen
then
that long
have
time
you?
ago, but a judge,
Okay.
yeah,
Yeah.
literally said he didn't accept the finding of the state agency RFC of,
Right.
I think it was probably, I feel like they put the person at heavy, and the person was this petite, tiny little,
Mm-hmm.
not a weightlifter girl.
Mm-hmm.
And the judge was very common sense about it, and it was a
Yeah.
good, it was
Yeah.
good in the end.
And that, by the way, might be a situation where it would make sense to do an in-person hearing as opposed to a telephone hearing. Now, of course, it'll be in the record, but if you walk in there and you are again, you're 4'9" and you're 90 pounds, a judge is going to look at you and say, how could you possibly do that? In fact, I would even tell a client in that situation, go to a gym or something, and how much can you lift? Just literally say, I went to the gym, my attorney's suggestion, I couldn't lift, 15 pounds because I'm just not very strong. All right, so No Sky puts on that we have 450 videos at my my YouTube channel. Thank you very much. And to please subscribe. Yes, very much. Thank you. And Al Brown says Middle Alexander is more likely degenerative disc disease, facet arthritis. That's probably correct.
It seems like
That's
they put it in so many different ways in the medical
yeah,
records,
yeah,
doesn't
yeah.
it? Yeah.
Right, no, right. You see, spondylosis or degenerative disc disease. It sounds really bad, but when you get to a certain point, you're over 50. Everybody's going to have a certain amount of degenerative disc disease or spondylosis. It just comes with the territory. Okay. All right. So Paul says he got a 4-month approval, met the grid rule. I wish I could say that was the rule more than the exception, but if you get it, that's cool. That's great.
That was how it used to be.
It was how it used to be. Yeah. Are low percentage judges shooting out good cases? How do they get it? I don't think they're shooting out the good. I think it's the opposite. They're shooting out of the more marginal cases. I think they approve the good cases, the really strong ones, but the ones that are, the person at 45 with a significant problem, they can find a reason not to approve that person, the 25-year-old. So if I had to guess, and again, I'm not seeing statistics, but a 30% approval judge, 25% approval judge, probably most of the approvals are going to be people over 55. And I think that the low, the cases that another judge might approve, recognizing that a 45-year-old can have severe Crohn's disease, can have severe degenerative disc disease, brittle diabetic, those are the ones they're not approving. So they're good cases, but they're not, let's say that the A+ cases are getting approved by that low percentage judge. The A-, B+ that other judges would approve, they're not approving. That's what I think is going on. Okay. Steph has fans. Yes, she does. She absolutely has fans there. Okay. How far back to look at your medical records? Okay, that's a very good question. What do you tell people? How far back, would you submit medical records? What's relevant in your mind?
Yeah, I know generally, right, the SSA is going to ask for, give us 1 to 2 years before your onset.
Right.
And they want to limit it to that. I do, depending, it's all very, depending on the case and the particular parameters of the case. I do like to get, I know the SSA might not order them, but I do like to get, if it's possible, certain diagnostics that might have been a couple years before then, particularly if they don't have anything updated yet, although of course we're urging them to get updated ones, or something that shows a progression, or let's say it's psychiatric problems and they have multitude of hospitalizations. Now, on the same token, current medical records should talk about that history already, so maybe that's not always going to be so pivotal, but yeah, I do like to get old stuff sometimes.
Yeah. Well, I mean, I think that if it shows a pattern, a decline, let's say, realize if you were working, right, let's say that you were working and you went to the doctor, started 5 years ago, have an MRI that shows a problem, but not a disabling level problem, but you were still working, Social Security can say, well, you were able to work through this, so obviously it was not inherently, by definition, not disabling. But it could show a pattern. And certainly in mental health cases, if let's say you've got high school records that show you had a problem in high school, that's very relevant. If you had, a psychiatric hospitalization at age 35, that could be relevant. So it's a judgment call, but if it's something that's relevant to, the history, helps tell the story. I talk a lot on my videos and on the live stream, you want to tell a story, have a narrative. When human beings are designed to listen to stories. And so if that's part of the story, part of the narrative, make it part of the evidence, that you can say, this is not a new problem. This is something, I fell off a horse when I was 18 years old. And yeah, I was able to work through that. But look, I had epidurals here and I had facet injections here. And I just, and finally got to the point I'm now 53 and I just can't handle it anymore. But it does show that history. And again, as Steph says, it'll be in the medical record probably. But, if you've got an MRI going back, then go ahead and submit it. It's not going to harm anything, I don't think.
And I think so psychiatric, it can be really.
I agree.
And like if there's IEP and if you can get them. I mean, you can't always get them, but.
No, that can show a long history of psychiatric problems. And look, I mean, I've made this argument before, and I think most people recognize it, common sense. As we get older, our ability to, to get past certain things, whether it's mental health or physical, it starts to decline. I mean, just, the accumulation of years has an effect. And if you've been dealing with depression, let's say, you may become less tolerant or less responsive to medications. You may have additional stressors in your life, things that have happened that make things worse. So yeah, I mean, I think that it's not unreasonable to say that with age not only comes experience, but your underlying conditions can get worse.
It might also.
Go ahead.
I was gonna say it might also be not with the under stages, but with like an ALJ. I don't know that it would be so bad to show that the person did always go back to work after the crisis. Always had that work endeavor, ethic, whatever.
Right, the work
And they
ethic.
didn't just try to go out on disability when they were 45, or 40 or 30. They pushed through it, and they did go back at. So sometimes I think that continuous trying shows its own story in terms of them looking at you now as someone who wouldn't be here, as you say,
Yeah.
unless they really hadn't, at this point,
Yeah.
they have no choice.
Yeah, I think that that's a very good point, that the more you can show that you are fighting to stay at work and that you want to continue, you don't want to be on disability. And yeah, I had back surgery 15 years ago. I went back to work. I had epidurals, went back to work. I had, a car crash, went back to work. But, now I'm 57. I can't. So yeah, I think that does show resilience. How long after your case was assigned to an adjudicator will you get a decision? It just depends. I mean, there's just no rhyme or reason to it. I mean, what used to be is it was sent to an adjudicator, you'd file your application, it would go to an adjudicator pretty quickly. Now, there could be a 5 or 6 month delay or longer before it even goes. It's just sitting there, metaphorically sitting there, and before it goes to an adjudicator. Once it gets there, you got to figure it's going to take the adjudicator 6 to 8 months at least to develop the record and to get a decision. But it could take longer and could be shorter if the case is, if you're 100% VA and you clearly meet a grid rule like the other gentleman talked about. So
in the last couple of years, I've even seen where there was an adjudicator on it, and then he wasn't for like 4 or 5 months, and then a new one comes on.
Yeah. Well, so look, they've had a
really
real
bad.
problem with people quitting. I mean, it is, there is, and I know the state agencies are technically part of the state, but, there has been statistics that, there's websites that cater to employees of the federal government and work federal government contractors, whatever. Social Security is like one of the worst places to work, unfortunately. It's just not a real pleasant place to work. And the VA poaches better people, they pay them more money. So, it's not unusual. You have an adjudicator and all of a sudden that person is no longer on the file. Then they got a new person in. And this is the problem. They can't keep good staff because they overwork them, and apparently there's real disconnect between management and the people on the floor, and then there's a whole issue with telework. There's a lot of stuff going on. It's not a it's a hard agency to work for. I don't think it's a great a pleasant place to work is what I understand. I don't know if you've heard differently, but that's what you keep hearing.
I just know there's the turnover and the short staff, and then that also means we don't have well-trained people.
Yep.
That don't really know what they're doing.
Yeah, it can be. And look, a lot of these people working really hard, but it's hard to when you're asked to spend half your time at the front desk doing replacement Social Security cards or answering the phone, it's really hard to get the training and get the experience and have the mentors. I mean, I read someplace where it can take over a year to get somebody trained, and that a high percentage of people, wash out within 5 or 6 months. So their numbers are less than they were 25 years ago. It's crazy.
Yeah. You got to pay them more.
I'm sorry?
They probably have to pay them more.
Yeah, that's right. And there's not enough money. Congress won't give enough money. Yeah. Okay. Okay. So I know Cancer Free has been on before. Is on 4 liters of oxygen continuously, 59 no income, can't get through to your senator. I don't know. I mean, to me, that's the, contacting the whether it's your representative or your senator. You got 2 senators, so maybe contact the other one. This is a frustrating situation. This gentleman, I can tell you from, previous weeks, clearly meets a listing. I mean, he's on oxygen, 24/7. So he meets a listing, but he can't get anybody to look at his case. So
because there's no adjudicator on the case?
Either that or the adjudicator is not responding. So I said, well, contact your senator. And he's like, I can't get them to call back. And so I'm like,
well, all right. I would go to their webpage. They all have a page that says help with a federal agency. It's ironic that sometimes it's hard to find that link because it used to seem very easy, but it almost seems like it's buried a little bit. Help with a federal agency. We do this not that infrequently.
Yeah.
And then they're going to get a release from you. Sometimes it's right online. You do it. You have to give your name, social, and you explain what's going on. obviously you're not asking them to award you on a listing.
Right.
They're not gonna put their thumb on the merits of your case, but they will send an inquiry, and that's gonna light a match under somebody's butt to get someone on your case
Yeah.
perhaps
But I think
faster.
what he's saying is that he's done that and nothing is happening.
Well, he said can't get through.
Yeah.
I thought that meant he tried to call.
I don't know. Now again, if cancer free, you have not filled out the form, and again, I hate to tell people fill out a form because
But
that's
it's what they require.
they
I've been
require
there
that, or
five
they're going
million
to want
times.
to
Yeah.
release. I think I would just say big picture, be a squeaky wheel.
Yeah.
You just got to be a squeaky wheel. If you're not getting able to get through by phone, fill out the form. Contact the other senator, contact your member of Congress. I mean, you got to be a squeaky wheel.
I will say
Because
this, if you can't, a lot of times their questionnaire will say, have you contacted another?
yeah,
And they might not, I mean, if you did the form with the first person and it's been, I would say even more than 2 weeks
yeah,
and they haven't gotten back to you, I usually hear back from them in
I
days.
agree. Yeah,
It's their
it,
team, you
yeah,
know.
yeah, yeah. You should hear back from them pretty quickly. Now, like I will tell you, in Georgia, we have a senator, Senator Ossoff, and I have dealt with his office because I do cases all over the country, but I'd say maybe 15 to 20% are just because I'm here are in Georgia, and so I've had a number of cases where Ossoff's office has been able to do that, and I've got a person there, their social security person. I can email her directly,
Yep.
and so it's I can shortcut that a little bit. But if you can't find that person, again, as Stephanie said, fill out the form, sign the release, whatever. If it's been more than 2 weeks, either fill it out again or check the other person. And if they ask you, have you tried with somebody, to say, I have, but they've not responded to me. You just got to be a squeaky wheel. Somebody
Yeah.
will eventually talk to you, but you got to
It's
be a squeaky.
usually, it's funny, like it's sometimes when you can have the person state they're gonna have two of those and they're gonna have their rep. I'm like, who's up for reelection next? Let's use
Hmm.
that person. You know what I
Yeah,
mean? Because you might get a
yeah.
little faster action.
And if I remember correctly, you've got an attorney, so I think your attorney should be also pushing this as well. Um, all right, Residual Hook. Um, what was the most back pay? Only go back a year. Okay. Again, I get this question a lot. You can get paid up to 1 year prior to your date of application. Again, assuming that your onset date is going back, before then. But it's not 1 year from the date of the decision. It's 1 year from your date of application. And in some situations, you can reopen an old application, but set that aside for now. So let's say that you claim an onset date of, 2 years ago, and you apply today, you can get paid up to 1 year prior to today.
You're never gonna go all the way back because
Right,
they don't go all the way retro.
right. You're not going to get right. If you claim an onset date of 2015, you're not going to get 10 years of past due benefits. So you're going to get, 1 year. And again, the 5 month waiting period would apply even before you're eligible for benefits. So let's say that you filed an application today saying I became disabled in 2015. And let's just say, for sake of argument, you get approved. The 5 month waiting period runs in 2015, but your payment would be, December of 23, if that makes any
And of course,
sense.
if you're not awarded until 2 years from now, you get that earlier year
Right,
and you get everything synced. So you could
right.
have
So you
back
could have
benefits
three
for
or four
three
years of
years.
past due benefits, correct, being paid in, but you only go back 1 year from date of application. SSI is date of application. SSDI, you can go back 1 year. But yeah, it's not limited to 1 year period. You could have, going forward, if it takes you 3 years to get the decision, you have the 1 year prior to the date of application plus the 3 years you've been waiting.
Yeah.
Okay. All right, L says you're within the way. Yeah, I don't necessarily agree with that. I think you can be you can really be a squeaky wheel, and especially if you're listening level, I think. Um, okay, disability cases, the appeals council. I don't think your congressperson is going to do much at the appeals council. That's my understanding. Do you have anything different? Would you agree?
No, I mean, there's only so much they can do. They have these people going through these cases.
Yep.
And I'm sure they still do, like if you're a vet, it's going to be like 100% vet, you're going to be have that expedited thing. That probably still applies there.
Yep.
But yeah, you
The appeals
can't,
council
it's
is
like
not
you
going to
can't get
be.
blood from a stone. If they only got X amount of people,
Yep.
you know.
Yeah, they're really a black box. Kelly's one of my clients. Hello, how are you doing, Kelly? Like a great rock concert. Well, Kelly, you've never heard me sing, so I will just leave that. And you don't want to hear me sing, I promise you.
Oh, you have no idea.
Yeah.
I mean, just listen to my voice.
Okay. Appeals Council said it'll be 15, 18 months. It could be. That seems a little long, but it could be. Hey, Mark. Mark's one of my clients. Hope you were doing well today. 12 months is the most given in California 12 months prior to application date, not 12 months total. Outsourced, I don't know, they don't really outsource it. The DDS is a state agency, so it's all initial applications are outsourced to DDS, if that makes any sense. DDS is part of the state that you live in.
They're doing the federal work
Yeah.
on your case.
Yeah. Okay, get a free case evaluation. Thank you.
I wonder if he's referring to, Jonathan,
this California disability.
There have been support, I don't know what the word is, support offices where I have seen a case get moved so that some office in a different state that has, they're moving things to make it go faster.
I've seen that too. Right. Yeah. So you may be in Florida and, an adjudicator in Iowa is now evaluating your case. So I've seen that. They move it around to try to, where they've got capacity.
Lighten the load.
That can happen. Yes. Not a lot, but it does happen sometimes. All right. Jen is my paralegal, senior paralegal in Nebraska, where I'm sure it's really cold. And I think I knew you had some stuff earlier today. So with the family. So I'm glad you were able to pop on. It's not just in California, Mike. It's back pay it's a federal rule, so it's not. I'm not talking about California disability, but for Social Security disability or any place, 12 months prior to the date of application. Okay, let's see. Jackie Padilla got my X-ray. So we got about 10 minutes to go, people. So just give you a little bit of heads up on that. We're gonna try to cut this off in about 2 hours because I need my beauty sleep, as you can obviously all tell, and Stephanie doesn't need it as much as me, but she has things to do as well. So, okay, got my X-ray for back pain. Found I've got narrow disc and the MRI to still work. So for major depression, do I have a chance? Again, I don't know how old you are, Jackie. So that's one thing. What is the specific diagnosis? I mean, narrow discs is not a diagnosis. So you need the MRI probably 27 years. I'm guessing you're probably in your 40s or possibly 50s. Again, it's not the diagnosis. It's the impact of the diagnosis on your functioning. Oh, she's 54, she said. The next one here. So, that may set you up for a grid rule case. Certainly at 55, it's going to be even better. So if you could hold on to 55, that's going to make your case stronger. But if you can't, you still have a grid rule argument if you're limited to sedentary work. But disc narrowing, maybe I think an L says stenosis. That could be stenosis is what she's talking about. So if you have spinal stenosis, which is kind of a narrowing of the space where the spinal cord goes, you need an MRI. So we need to see what the MRI says.
MRI, that's what I was going to say.
Yeah, it'll tell you and how severe it is. And then what are the functional limitations? Hattiesburg, Mississippi. I actually have a case with a judge in Hattiesburg on Friday. So I think it's Hattiesburg.
That's a coinky-dink.
Yeah, it is. My client's in Florida, but they got the judge. I believe it's Hattiesburg, someplace. I think it's Hattiesburg. But, again, you have to look at the judges. There may be 15 judges in the Hattiesburg hearing office. one or two of them may have a higher approval rate, one or two may have a low approval. It depends on the individual judge. You can't really, at this point, I don't think you can say a particular hearing office has a personality. So it's the individual judges. Some hearing offices, you have a higher number of low-paid judges, but I don't know that Hattiesburg is one of them. Okay, applied New Jersey in May. That's your neck of the woods. Denied. Sent for medical recon. Denied last month. Request for hearing. 6 and 8 months. Yeah, I think that sounds about right. To get a hearing about 6 or 8 months. Yeah, I would think that's about right. And again, you don't say what's going on, but hopefully 58. You may have a shot at the grid rule. And as a teacher, I think that makes a difference too. I think teachers, nurses, people that do a job that's more of a calling than a job. You're not going into teaching for the money. I think judges appreciate and respect that. Many of them do, at least. Manitz, 11 years ago, granted SSDI. Toughest judge, was very young, expecting a good check, to take a pay cut, be approved now. So I'm thinking your attorney said take a changed onset date, not a pay cut. So, because they don't change the amount of your benefit. But if you had a tough judge and you got approved at 31, then probably wasn't a bad decision by your attorney, again, without knowing more facts. Okay, L makes a point, yeah, as far as the diagnosis, this is the person who needs the MRI. That's correct. Okay, Doug says, all right, so Manit says, Michael, I think we've talked about that before. Doug, thank you for your videos. Okay, you're very welcome, Doug. We are happy to help you. Okay, let's see. Let's try to take a couple more. We got about 5 more minutes here. We have Golfer Pro 2, carpal tunnel. I think it's just the gentleman who's 58.
Yeah.
Okay. Bilateral carpal tunnel, stenosis, lumbar cervical disc, sciatica, 30-year work history. Yeah, I think you got a grid rule argument there, 58. I think you can make a pretty good argument you're limited to no more than light work and probably no transferable skills if you have significant pain. Okay. All right, so, but surgery scheduled. I think that's an interesting point. I think that if you have surgery scheduled, anytime, judges see surgery, that's an indication you got something pretty severe. So that's certainly I think a relevant point. All right, so we're just kind of zooming through some of these. Okay, so I'm not going to go through all. There's an ongoing conversation between L. Brown and Jackie Padilla and Manitz. I'm not going to go through all of those there. I think these are all very legitimate points. And basically, just you would need to have objective evidence. Surgical recommendation is going to indicate severity. I would agree with that. Okay. Okay. Let's see here. Okay, here's somebody new, Carla Lewis. I'll be 62 years old in a week. Well, early happy birthday, Carla. I've been on SSDI for 6 years. Never had a CDR. They don't see one scheduled. You're probably not going to have one at 62, would be my thought.
And they don't have it scheduled, so it doesn't even sound like she has a diary.
Yeah, yeah. Interesting. Okay, can a president clear SSDI denials like a pardon if he wanted to? I don't know that it's, I don't know. But you know what? If you're going to try, you got one in here who certainly likes to use that pardon pen. So I don't think he could. I don't think he can approve your case or whatever. I don't think that's the same thing. It's a criminal pardon. But that's a great question. I love it. Yeah, that's a very good question. I wonder if a Freedom of Information Act could get more granular information. Possibly it could. I don't know. I've done those a couple of times and never really got much out of them. I think to do these right, it's kind of like Chat GPT. You have to write your Freedom of Information request very, very specifically to get the right kind of answer. Okay. Okay. If you have a business saying God is good, it's a law library, it's disability issue due to. I wish I knew what you're. I don't know what you're asking. I'm sorry. Okay. Jessica says, do hypotheticals during an SSDI reflect your case? Yes. Yes, basically the judge is trying to come up with something called your residual functional capacity, which is the amount of capacity you have left over when you factor in your impairments. And so each of the hypotheticals reflects an RFC assessment. One of those becomes the basis of your decision. So yes, it's all very, very relevant. Okay, let's see if we can get one more, and
And I
then
would say that, Jessica, if you hear one of the hypotheticals that says all jobs excluded,
yeah,
that's the one you want the judge to pick when he's making your decision after the fact.
yeah. Okay, so St. Louis says that I think the problem was on my end because what was happening is I have speakers to either side of me here. I turned the sound way low and I've got my microphone right here. So I think what was happening was your conversation was picked up by my speakers. So I'm either going to use a
Ah.
headset or just keep it low, which
Well,
is what I'm
good to
doing
know.
today.
Thank you, St. Louis.
Yeah, okay.
Or S. Louis, I should say. I always say St. Louis, don't I?
Yeah, okay,
Grande.
okay. All right. We'll take one more and then we're going to call it a night. I'm Just Dwight says, I'm 58, working with sarcoidosis, lung disease, pulmonary hypertension, bronchiectasis, emphysema, etc. 100% VA, plan to file for SSD. Is this a good plan? How would you analyze this, Steph?
He's got some really severe stuff.
Mm-hmm.
I mean, is he waiting to 60 to retire for some reason? Is his job hurting his health now? I don't know.
Yeah.
Because those are like, depending on the hypertension, everybody has that. So
Yeah.
but emphysema, sarcoidosis can be really tough if it's, if you get your flares. I'm waiting on a decision on a young person with sarcoidosis, amongst other things, because it seems to maybe come with other things. Yeah, I mean, are you having trouble working?
Yep.
Like, he's planning on waiting 2 years.
Yeah,
I
I
don't
would
know.
say that my thought would
know.
be obviously work as long as you can work. It's 60 now with these conditions. They might impact your functional capacity. What do you think about using the grid rule here? Could you argue this person would be limited to light work because having emphysema probably couldn't be on his feet for 6 hours?
I'm going to say it wrong. Bronchiectasis. That one can be really bad with breathing. God, there was a case I had a long time ago. I mean, and young person,
Mm-hmm.
that would go along with pulmonary, I would think, right? And sarcoidosis.
Yeah,
There's
I
like
think
such
you
an
can make a
overlay
grid.
of,
I think you can make a grid rule argument, and at 60,
for
realize
sure.
that the Social Security's burden to prove transferable skills becomes really, really high. There's the PALMS regulation, which basically says that they have to prove you would have to make minimal vocational adjustment, even at light. So I think at 60, you probably have a good case now, but I think at 60, yeah, that's a good. I would say answer your question. Yes, that's a good plan, assuming you don't want to continue to try to work. I think working is a better plan if you can do that. But if you can't work, I think that this says to me you've got a pretty compelling argument.
Yeah, because I think those things would, when it comes to breathing and stuff, that definitely affects whether you can do light work even.
Physically, yep, I agree.
At the
I
lower
agree.
levels, they might be like, oh, you can do light because it's light. But I think
Yeah,
a judge is going to look at
the
it
judge is going to
differently.
see that. Okay. All right. So we're right at 2 hours now. Steph, obviously, always good to see you. I appreciate you coming on, giving your insight. Any comments, any last thoughts before we close for the evening?
I hope everyone has a Merry Christmas or a Happy Holiday
Yeah.
coming up.
Okay.
I hope they
Being
had a great
politically correct.
Thanksgiving.
Okay.
Yeah. So just stay well and
Stay warm.
stay tough with your case.
Yeah.
Yeah, I'll stay warm.
Yeah.
That's
I
my
would
plan.
just say that, and we talk about this every week. You got to be your own advocate. You got to be willing to be a squeaky wheel when it comes to reaching out to your Congress people. Don't sit and wait for Social Security to do anything. They're just overworked, and you just have to just make their life as easy as possible. Get them stuff. Get them medical records if you can. Make the argument. Don't just sit around waiting because you'll wait forever. And stuff gets lost. The agency is not in a good place right now, and obviously people that are applying need their benefit. there's a lot of hurry up and wait, but just, during that time, keep them updated, keep going to the doctor. Um, it's a tough road. It's a real tough road. And it will be
Yeah.
interesting to see when they come up with a new commissioner. The current, right, Commissioner O'Malley resigned. He's going to run for the head of the DNC, Democratic National Committee. And Carolyn Colvin, who was a former commissioner, has been brought back out of retirement. She's not going to do anything. And there may be a big fight in Congress about a new commissioner. So, things are going to sort of stay static, and nothing positive is going to really happen for a while, is my guess. So
Yeah.
just keep
Do
keep
you
the faith.
do you do you know if they have if there's a plan, at least a plan? You know how we can see, we can go into the electronic file,
Yep.
we can see if someone has added something
Yeah.
from the
Yeah.
SSA side.
Right.
Can the claimants,
I
they
don't think
can't
they
get in
can.
yet on their
That
side?
what Stephanie's getting at is that as we can access your file electronically, and so I can see, Stephanie can see the adjudicator has obtained medical information. The adjudicator is requesting stuff. I can also
Something.
see nothing has happened for the last 4 months. So we can see that. I don't think you can. We can see that because we have electronic access, but they don't give you access to your folder. So I don't think that the individuals can see. They just have that stupid 30%,
Oh,
thing.
the nonsensical
Yeah.
messaging, it drives
Yeah.
me nuts. But I wonder, is that something that they were talking about doing, or are they like,
Not to
no,
my
we really don't
knowledge.
want claimants having their
Yeah,
file?
I think that my sense is they want to give people enough information where they think something's happening, so they won't call the adjudicators and try to complain too much. But in essence, nothing much is really happening. Is really what's
Yeah,
going
yeah,
on.
yeah.
So
And maybe
yeah,
they're thinking if claimants have access to their what's been
yeah,
going on or not going on, they're going to start calling more. They don't want them to
yeah,
call more, and then
yeah.
yeah,
Okay. All right, so Steph, hang on for a second, but we're going to go ahead and shut the live stream.
sure.
I appreciate everybody's attendance here. We
Hi,
will
everybody.
hopefully we'll see you next week, and again, stay warm. And if we don't see you before the holidays, have a Merry Christmas, Happy New Year, Happy Holidays, and again, just stay safe out there. So we're going to end right now, and see you next time.